So now you come to the issue with respect to contract documents. You're going to have times where different documents say different things or have different standards, or have different dimensions, specifications, etc. So how do you deal with that, especially on the front end when you're trying to bid the project? So some contracts, especially the state contracts you have here in New York, are going to have an order of precedent clause typically. And all that means is they're going to list out the documents, the contract documents, and they're going to tell you which one controls over the other. I gave you an example here. Consensus Docs actually does this in their contract. They put change orders first, because obviously you're changing the contract, so that should take priority. Then the actual contract, the agreement. And then they list drawings, large scale over small, and then specifications, then owner information, and then other contract documents. Consensus Docs also has some nice saving language here that despite that order of precedence, if there's a term or provision that's conflicting, you're going to use the one with the latest date. If for some reason something's issued a few weeks later, you would use that information as opposed to the original. If you get into your New York agency contracts, DOT, DEP, DASNY, etc., you're going to see some specific language with respect to drawings controlling over specifications. You'll also note, and I point out here, the OGS general conditions for New York State. They also say the less stringent and less expensive provisions take precedence over the more stringent and expensive. This is quite nice because it's the exact opposite of what you're going to find in most owner-modified contracts, right? They're going to require you to do the more stringent or the more expensive whenever there's a conflict. But New York's OGS general conditions, which are reflected in a lot of the agency contracts, only require you to do what's less stringent or less expensive. I've also seen plenty of times where even within the specifications, division one of the specs, the general is going to trump the rest of the specifications, control over it. So for subcontractors, again, the subcontract is often going to control all the other documents. So if there's a conflict between the subcontract and the prime, there may be language in there that says the subcontract is going to control. To flip it, if you look at consensus docs or if you look at most federal contracts, they actually state that the specifications take priority over the drawings. Again, the New York OGS says drawings take precedence over the specs. So pay attention to it. We all know that there can be some pretty significant discrepancies between drawings and specifications. When in doubt, and we'll get to this later, but when in doubt, as soon as you identify that ambiguity or conflict, give written notice to whether it's the project engineer or the architect and the owner of that, requesting additional information. When you're signing an AIA contract that has been modified, they actually don't have an order of precedence clause. They take what's called a complementary approach. Essentially, all the contract documents are complement each other, and so you're going to interpret them that way. And who makes this interpretation if there's a conflict? Well, it's typically the owner or the architect, which is not going to go in your favor. But even so, your owners often modify the AIA to include language, and you'll see this in a lot of contracts. It's sort of the opposite of what we just looked at, where you were required to perform the less stringent or less expensive. Well, owners typically want you to perform whatever requires the better quality or greater quantity of work, or to comply with the more stringent requirement. Again, you're going to see that the architect or the owner is going to make that determination. So be very careful, when you're putting your bid in, if, especially if let's say you're a GC early on, and the design is not 100% complete, you really want to keep an eye on this. You don't want to put yourself in a position where you're really bidding on one scope, but because the specs that come out later or some revisions to drawings that come out later change it, the owner can somehow require you to comply with that more stringent requirement. That's why it's so important to have a clear definition of what is a contract document and what is not, and then what takes precedence. Okay? If there's no provisions, which you see sometimes, then you kind of default to common law. I'm not going to bore you here, but there's quite a few drafting, contractual interpretation standards clauses that the courts use. Typically your specific is going to control over your general. So if you're required to do one thing, but in the specifications, it gives you far more detail on that requirement than the specification. The court will find that the specification is going to control because it has the more information, the more specificity. You're also going to see courts tend to interpret contracts against the drafter, meaning the person who actually drafted the contract. That is why in almost all contracts now you see, at the end of the contract where they throw in a bunch of clauses under miscellaneous, you'll see a clause there that speaks to joint drafting of the contract, even though you may have nothing to do with that. You were given the contract and you had to sign it. You're affirming that the contract was jointly drafted and that there's going to be no favoritism as far as how a clause is going to be interpreted against one party or the other, which would normally be the default rule. The owner, as the drafting party, would be construed against the owner as opposed to the general contractor. So, what are the contractor's obligations with respect to conflicts? I mentioned this before. And again, this goes for subcontractors as well. So most contracts do have some kind of document review clause. So with consensus docs, it requires the contractor or the sub, you have to examine, compare the drawings and specs, the relevant field measurements, any visible conditions to the work site affecting the work. And if that review pops up errors, you have to promptly report them to the owner. AIA takes a similar position. Again, you got to review the contract documents, make sure they comply, make sure the field measurements are correct. Of course, the question comes up in both of these situations, well, what if you don't? So importantly, consensus docs, realizing that this can kind of, I think, shift into kind of an improper delegation of design. You're a contractor, your means and methods, you should not be tasked with reviewing the plans to make sure they meet code, to make sure anything that has to do with design or engineering aspects of it. So in that vein, consensus docs actually state specifically it's only meant to facilitate construction. That you as a contractor have no responsibility to detect errors, omissions, inconsistencies, compliance with the law, building code, or regulation. That's very important language, and it's language that is not found in many of the owner-modified contracts. And again, you have to be very careful of this because you start to get into insurance issues. Whether or not your general liability is going to cover a claim by the owner with respect to a failure to detect an error of the plan, things of that nature. So again, it's to facilitate construction, to detect errors, omissions. So the AIA, again, has some good language in it that the review of the contract documents is only for the purpose of facilitating coordination and construction by the contractor, not for the purpose of discovering errors, omissions, or inconsistencies. With the AIA contract, if you're getting a modified AIA contract, whether you're a sub or you're a GC, it should be redlined, so to speak. You're going to see on the margins where it's been changed, and it should come with an additions, deletions report, either attached to it or it should actually be redlined in the agreement. If it doesn't, you need to ask for it. Don't assume that you're signing the form contract because you likely are not. And things like this may be taken out or altered and you may not catch it. So even with this language, though, you can't ignore errors in the contract documents that you discover. And that goes for AIA, goes for consensus docs, and also for subcontractors. I gave you some example language from consensus docs here. Subcontractors not going to have any liability, for the errors in the contract documents unless it knowingly fails to report a recognized problem to a constructor. Consensus docs calls the contractor constructor, and AIA calls it contractor. It's kind of one easy way to know what contract you're dealing with. Now, I said from the owner's perspective. So this is typically what a private owner may do on a large job, especially one that use the architect for the plans, but the architect's not doing construction administration. Maybe it's an owner's rep. Maybe it's a CM not at risk, and you'll see language such as this. So they're going to put language into the clause we just looked at. It's actually going to hold. You have to hold them, the owner, harmless for any error or conflict that either was or should have been discovered. And the should have been is the key here. There's a specific acknowledgement also they put in there that I, the contractor, have reviewed the contract documents. I find them sufficient and complete, and they were accurate enough for me to determine the correct contract sum, the correct contract time. All of this language is put in there to prevent you from later claiming either by a change order or a claim, extended time or in addition to the contract sum for issues that come up as a result of the drawings or the specifications being out of whack, being out of code, requiring something else entirely. You having to go back and redo work because of it. So prime contractors then often make kind of similar revisions to their subcontracts. Again, everything gets pushed down, right? So I've seen this where it's the subcontractor shall not at any time make claims alleging insufficient data or incorrectly assumed conditions or conflicts in the contract documents following execution. Now, this is a pretty tough clause here. Again, I'm not discussing whether or not this would be enforceable in court of law because, quite frankly, you're not going to be able to test it in most situations. If it's being used against you, you're going to have a difficult time here. So be on the lookout for this. You may not have much power as a sub, but I find that you often can at least negotiate 2 or 3 key terms to at least be back to the default rule. You may not be able to get them in your favor, but at least to a more level ground. The same goes with contractors dealing with owners and their modified documents. Reasonable requests for changes, I think, are often at least considered by the owner. All right. You also are going to see that the contract review, and this is really important, it's not just confined to the contract or the general terms. And many of you who work on public jobs know this, right? So you get the project manual, part 1 and part 2, because they're so big they can't fit in one email, and it has all the specs in it. A lot of times, the architect who's making up that spec puts in contract review requirements or work review requirements that are not in the prime contract. And it's not till later that you realize when you get the letter from the architect citing some obscure specification as to your requirement to give notice on some issue that, oh, okay, this also applied. It can be buried sometimes in these huge spec books, but be on the lookout for them. And I'll give you an example of something I recently saw on a public school project. Again, in the specifications, not in the prime contract or the general conditions or the modifications that were made by the owner. This was in the specifications. And it required the contractor to immediately, when he discovered issues with respect to contract documents, they had to submit a request for information to the architect. and here's the key part, failure to do that timely was an express acceptance of any such differing site conditions. And the owner shall not be required to make any adjustment in the contract sum or contract time. Now, obviously the architect's putting that in to save, its own butt. This is, and the way I've seen this applied, it really can be egregious. So what's the answer? If you can't make revisions to it, you're stuck with it, highlight it, put it on the front. Let your project manager know on this job, if there's ever an issue, here's a template letter. This has got to go out ASAP, and cite the specification in the letter. Never waive a claim because of a failure of written notice. Once you have that system in place, it's something that you can easily do, especially on the larger jobs where with public owners, that no one's going to get too offended by receiving a notice of claim on an issue like this. And I call the owner, call the architect up beforehand, say, look, I got to do this just because of the specification, so expect this, and you can move along. But at least you have that documented, and you show that you followed the required notice provisions.